An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Cooper versus Aaron, 1958. Brown versus Board of Education was decided in 1954. At the time, nearly 24 states racially segregated their public schools. Brown considered the constitutionality of the laws in 4 of those states: Kansas, South Carolina, Virginia, and Delaware. In a unanimous decision, the Warren Court found that segregated public schools violated the 14th Amendment. However, the court did not order that all schools nationwide must desegregate immediately. Instead, the court ordered re-arguments on how to implement the decision. 1 year later, in a case known as Brown versus Board of Education 2, 1955, or simply Brown 2, the justices instructed the lower courts in Kansas, South Carolina, and Virginia to, quote, enter such orders and decrees consistent with his opinion as are necessary and proper to admit to public schools on a racially non-discriminatory basis with all deliberate speed the parties to these cases. These states were now bound by the Supreme Court's judgment to integrate their schools with, quote, all deliberate speed. But what about the other states that were not parties in Brown? Cooper versus Aaron, 1958, would resolve this question. In 1955, the Little Rock, Arkansas School Board approved a plan for gradual integration. However, as the, quote, massive resistance spread to Arkansas, citizens approved amendments to the state constitution that opposed Brown and desegregation. Based on those amendments, a state court judge issued an injunction that halted the integration plan at Central High School in Little Rock. Study guide. Brown only involved cases from Virginia, South Carolina, and Kansas. Was the Little Rock School Board bound by Brown 1? By Brown 2? In response, a federal district court issued an order to block the state court injunction. The situation escalated quickly. Governor Orville Faubus ordered the Arkansas National Guard to prohibit black students from entering Central High School.
Units of the National Guard have been and are now being mobilized with the mission to maintain or restore the peace and good order of this community.
The National Guard blocked 9 African American students, known as the Little Rock 9, from entering Central High School. Neither Faubus nor the Guard were bound by the previous court order. After a federal court enjoined the National Guard from blocking access for African American students, the Little Rock Police Department took their place. The police had not been included in the court order that bound the National Guard. 2 days later, in one of the more dramatic moments of the Civil Rights Movement, President Eisenhower dispatched the 101st Airborne to Arkansas.
Order ceases at once. Mob rule can not be allowed to override the decisions of our courts.
These storied federal power troopers had fought their way across Europe in World War II and held their ground at the Battle of the Bulge. Now, they were deployed to Little Rock, Arkansas. The troops escorted the Little Rock 9 into Central High School. Throughout the remainder of the year, the students attended class under the supervision of federal troops. Study guide. What would have happened if President Eisenhower chose not to send in federal troops? Even after the federal intervention, the opposition to the desegregation plan did not subside. As a result, the district court granted the school board a 30-month extension. The judge found that a delay was warranted because the integration plan had caused, quote, chaos, bedlam, and turmoil in Little Rock. The Eighth Circuit Court of Appeals reversed the district court's judgment. The school board did not advance a sufficient basis to suspend the integration plan. Shortly before the start of the semester, the Supreme Court convened for an emergency hearing. The question presented was fairly narrow. Was the 30-month extension given to the school board consistent with Brown's requirement to integrate with all deliberate speed? During oral arguments, the lawyer for the school board told the court
that it was certainly not anticipated at the time that plan was formulated that the governor of the state of Arkansas would call out troops to keep integration in the schools from taking place.
Therefore, he claimed a delay was warranted, but the court was not persuaded by this argument. Chief Justice Earl Warren asked the attorney,
"Can we defer a program of this kind merely because there are those elements in the community that will commit violence to prevent it from going into effect?"
Ultimately, the Supreme Court ruled that the delay was not proper. The court concluded, quote, "The constitutional rights of respondents are not to be sacrificed or yielded to the violence and disorder which have followed upon the actions of the governor and legislature." In an unprecedented showing of unanimity, the opinion was signed by each of the 9 justices. However, the court did not stop with this straightforward conclusion. Instead, the justices answered the premise of the actions of the governor and legislature that they are not bound by our holding in the Brown case. Article 6 provides that the Constitution, quote, "shall be the supreme law of the land." Study guide. Does Article 6 state that a decision of the Supreme Court is, quote, "the supreme law of the land"? The lawyer for the school board suggested that the people of Arkansas believed it did not.
If the governor of any state says that a United States Supreme Court decision is not the law of the land, the people of that state, until it is really resolved, have a doubt in their mind and a right to have a doubt.
He added,
The school board, a creature of the state, is placed between the millstones in a conflict between the state and federal courts.
Once again, Chief Justice Warren was not persuaded.
But I have never heard such an argument made in the Court of Justice before.
Thurgood Marshall, arguing on behalf of the NAACP, urged the court
to make it clear, even to the politicians in Arkansas, that Article 6 of the Constitution means what it says.
The court agreed with Thurgood Marshall. In Cooper, Chief Justice Warren interpreted Marbury v. Madison to mean that the, quote, "interpretation of the 14th Amendment enunciated by this court in the Brown case is the supreme law of the land." Therefore, all politicians in Arkansas were bound by Brown by virtue of the Supremacy Clause. Study guide. Did Marbury hold that the decisions of the Supreme Court are the supreme law of the land? The immediate aftermath of Cooper was bleak. Hours after the case was decided, Governor Faubus leased all the public schools in Little Rock to a private corporation, which was not bound by the 14th Amendment. After the courts halted this scheme, the government simply closed public schools for the remainder of the year. Indeed, schools throughout the country shut down rather than integrate. Having made its decision in Cooper, the court would wait nearly 5 years before hearing another school desegregation case. Ultimately, schools in Little Rock would not be fully integrated for more than a decade.